just briefly, I'm going to introduce probably they're well known to everybody except maybe one. So Theo Liebman, who is on the very end, who's holding his jacket over his chair, is clinical professor and the attorney in charge of our youth advocacy clinic here at the law school. Loris Wren, who is next to me, is the clinical professor and attorney in charge of our asylum clinic here at the law school. Steph Krieger is our professor of law and attorney in charge of the law reform clinic here at the law school. And last but not least, Emily Ngara, am I pronouncing that correct? Is our visiting assistant clinical professor of our attorney in charge of our new deportation defense clinic that we just launched this year. And formerly coming from UVault and UDC, right, as clinical fellow positions there. So I'm going to give about 15 minutes of an opportunity for each of them to talk a little bit about their perspectives about what's going on in our current administration with respect to immigration policy. And then we will open it up. We really want to have time for you all to be able to ask questions. I have some prepared questions if there's crickets in the audience, but my sense is that you guys probably do have a lot of questions that you'll be prompted to ask, if not just based on what you're reading in the headlines, but what you're hearing from our panelists. And I just wanted to start off by saying that I was a little bit struck. My hope is that many, if not all of you in the room, were able to hear Justice Sotomayor's remarks on Monday evening here at the law school. And she began, for those of us who did hear it, in relaying the story about Justice Souter inviting her into chambers and talking about, just kind of orienting her to what it was going to be like to sit on the Supreme Court. And one of the things that he had talked about was giving her a little bit of a warning of whenever she is interacting with her colleagues, particularly as debates can get contentious among the members of the court, as they can for all of us in various contexts, to think of all of her colleagues as people of goodwill who have different opinions, but all of whom share a passion for their work, for our justice system in the United States, for our Constitution, and all have a love of country as well. And his guidance to her was, if you can keep that at the forefront of your mind, then hopefully that can help all of us engage in civil discourse on issues that might well prompt a lot of controversial arguments and opinions and passion. And another thing that she said somewhat near the end of her remarks was that she impressed upon all of us that immigration is a highly contentious issue in our country right now, but that it's one that is our issue and one that we have to come to some answers on with respect to how we are going to proceed on these policies as a country going forward. And in doing so, we have to really understand the various motivations and fears that are driving the positions that people are taking. So, with that as an entryway, I'm going to ask Professor Liebman to begin.
That wasn't me.
Okay. Let me say one more thing, actually. I wanted to make an announcement. We have an upcoming event on October 30th from noon to 2 in room 230, Justice for All, Moving Towards Civil Gideon in New York. We are going to be honoring our own Judge Fisher, who is here, and we are incredibly grateful to have snatched her away from the New York court system into our law school and to help us as we are all wrestling with these issues. But particularly Civil Gideon is a very important issue that the New York court system and the New York State Bar and practitioners here in our state have been struggling with. And so I strongly encourage you to come and attend that event. There's a bunch of flyers that will be up around the law school, but it will be here Monday, October 30th, noon to 2 in room 230. No.
Thanks. So before I get started, I do want to say it's very like a Yankee fans who somehow complain about a victory, and you're not getting any sympathy from me. Mets fans, we have a lot more to actually complain about. So the other thing I want to say is that I'm going to be speaking about executive orders and policies that affect children and youth, and I'm going to focus on two things. I'm going to focus on DACA, Deferred Action for Childhood Arrivals, and the DACA rescission. And then I'm also going to focus on a number of policies and rules that the Trump administration has enacted that are primarily in response to the surge of immigrant children and youth who've been coming from the Northern Triangle in Central America, which is Guatemala, El Salvador, and Honduras. So I'm going to focus on both of those. When I decided that those were the topics that I wanted to address and felt might be of most interest, I felt a little sorry for myself that so much is changing with DACA, and there's a new tweet every day that indicates a different position that Trump might take. And then Professor Wren, who's speaking about the Muslim ban, of course there were two new decisions, one yesterday of 40 pages and one this morning of almost 100 pages that she has to now incorporate into her presentation, so I didn't feel like I could actually complain, kind of like a Yankee fan complaining. So DACA, Deferred Action for Childhood Arrivals. In order to get sort of a full understanding of what Trump's administration has done, you do need to go back a little bit to understand where DACA comes from. And I think most of us probably know that Deferred Action for Childhood Arrivals was an executive action undertaken in the Obama administration, but it actually goes back even further than that. Since about 2001, there have been various senators and members of the House of Representatives who have tried to enact legislation that would provide a pathway to legal status for individuals who were brought to the United States as minors, as children, and did not have status. And there was a feeling that for these individuals, they were brought here, it wasn't their responsibility, it wasn't their fault, if you want to look at it that way, that they were brought here without permission, and now they're here without status, they've grown up here. As the saying goes for a lot of what are called the dreamers, we're American every way but on paper. And there was a feeling that this was a group that we should give a pathway to lawful status here in the United States because they were blameless. And so there were various legislative initiatives that were put forward, and some came really close to passing, but none of them ever did. And so what Obama did was say, okay, I cannot legally provide a pathway to legal status here in the U.S. I cannot, as the president, enact a law. But what I can do is enact an executive action that essentially, within my powers as an executive, provides a break for those individuals. And the break that Obama provided was really twofold. One was deferred action, meaning we're not going to prosecute you, we're not going to try and remove you from the United States because we have prosecutorial discretion as the executive branch. And so there are other priorities that we're going to be looking at. So if you're here and you meet certain criteria, that I'll talk about in a minute, you are not going to be someone that we're going to be pursuing to try and remove from this country, even though we know that you're here without status. So that was sort of the part one. And then the part two was, and while you're here, we're going to give you work authorization, an EAD, an employment authorization document, which allows you to work here legally. You can use that EAD, you get your tax ID number, you pay taxes, you're perfectly legitimate and legal as a worker here. And that's a huge benefit for a number of reasons. One, it opens up opportunities for these individuals, but it also means that sometimes they can use that. That's an ID. They can, in some states, get a driver's license. So it makes their life much more normalized, having that employment authorization document, that work authorization. And each of these run together, the employment authorization document and the deferred action, for 2 years at a time, and then you have to renew it. And under the rules, in order to qualify for that, you had to have come to the country when you were 15 or younger, and you had to have arrived here before 2007. So we actually in the clinic had a number of clients who came in 2008, 2009. They were not able to get DACA status. So we had to see whether there was other relief that we could pursue for them. But you had to have arrived before 2007. You had been 15 or younger when you arrived. You had to be in school or have graduated from school. And you had to basically stay out of trouble with the law. I don't want to go into the details. You could be in minor trouble, but any kind of significant trouble with the law, and you could not qualify for DACA. And you had to be under 31 or under as of June in 2012. Okay, so if you met those criteria, then you could get this deferred action. It was not a pathway to permanent status. And when the Trump administration came in, one of the first executive orders that was issued and the Department of Homeland Security implementation memo of that said, kind of up front on one of the sections, we're not touching DACA. Didn't say it that way. But basically, that's what it was saying, is DACA is staying intact. We're not at this time touching DACA. So that was a very big relief for the 800,000 people in the United States who have DACA status. Remembering that a lot of the individuals, almost all of the individuals who applied for DACA status, were not previously known to the U.S. government. Their addresses, their names, their date of birth, their contact information, etc. So it was a leap of faith for these individuals who actually put out there all of that information about themselves to the Department of Homeland Security, which is the same agency that's responsible for prosecuting people here who are not here with authorization and removing them. So they put that out there, so it was a big relief when it appeared, at least for the time being, that DACA was not going to be touched. Then, September 5th, 2017 of this year, after basically it was about a week or two of indications that this was going to be ending, Trump, through his Attorney General, Jeff Sessions, announced that DACA status was going to be ended as of March 5th, 2018, so 6 months. And after that, DACA status was going to be ended. If you had DACA status and a work authorization that expired before that time, you had an opportunity for one more renewal if you got it in by October 5th. But other than that, the status was going to be ending on March 5th, 2018. So if you look at the grounds for that, Sessions essentially said that the grounds were that the initial executive order was not constitutional because it essentially took over the role of legislating from Congress when it initiated these, and that it was not the role of the executive branch to enact any kind of rules of this kind that could grant this kind of status. That is a view that most scholars disagree with. The vast majority of scholars disagree with that view, but there are certainly individuals who do believe that the initial executive action was not constitutional. So what Trump did after that was enacted was basically say, part of the reason I'm doing this, maybe even the main reason I'm doing this, is it's not okay for the executive to enact rules like this. This is for the legislative branch. So you, Congress, I want you to enact legislation that protects these young people. And in fact, that would be much more of a safety net for these individuals because it would provide a pathway, hypothetically, to legal status for these individuals who are here. It would be wonderful to have Congress pass what people call the DREAM Act. And the DREAM Act is a pathway to legal status for these individuals. And there was some hope among a lot of people that that might happen. That hope has dissipated somewhat, a lot, because of a recent sort of missive that the Trump administration sent to Congress saying, look, if you want DACA, here's the laundry list of things that have to be included in any legislation that provides a DREAM Act. And a lot of senators are saying that that laundry list is completely unrealistic and is a non-starter. So that's where we are right now on DACA. And I'm happy to answer more questions when we get to the questions. How am I on time? 2 minutes. This is great.
Sorry, 4 minutes.
4 minutes. All right. 4 minutes to talk about orders targeting the surge of minors from the Northern Triangle. Okay, very briefly, starting in about 2013, there was a dramatic increase in the number of children, minors, coming from Honduras, El Salvador, and Guatemala, in the tens of thousands, a dramatic increase. A number of studies have been done about this, which show that the primary driving factors are extreme poverty, violence in the communities, violence in the home. If these are the primary factors driving these children to come, the vast majority of the time unaccompanied, dangerous journeys to get here into the United States. And that started in 2013, really, that surge started. Going from about 20,000 in 2013 to 40,000 in 2014, then back down to about 30,000, then back up to 50,000. So it's fluctuated a little bit, but always in the tens of thousands. A number of aspects of the executive orders that came out shortly after the Trump administration took over really are targeted to kind of address this increase, this surge in the number of minors coming. And they're really, I would just mention two of them. One of them is a new policy that when a family member or parent pays someone or helps pay someone in some way to bring their child or family member across the border without authorization, that ICE, the Immigration and Customs Enforcement, and Border Patrol should be going after that individual either for criminal prosecution or for removal proceedings if they're removable. So to explicitly target the family members who are paying for someone to bring a child across into the United States without authorization. So that's one piece. And then another is sort of a number of different orders, really, that talk about scrutinizing much more closely applications for humanitarian relief from immigrants generally, but also explicitly from unaccompanied minors. What I have now? 2 minutes, this is great. All right, we can do this in 2 minutes. So, what have been the effects of this? I mentioned the numbers before. So far, year-to-date fiscal year since the Trump administration took over, there have been about 30,000 unaccompanied minors apprehended. That's down from 47,000 for the same time period in 2016. So that definitely seems effective. When you go back 2 years, though, it was below that. It was 28,000. Okay, so it actually is an increase from 2 years ago. The year before that was 52,000. So what we have this year is down. The year before that was 21,000, so it's up from that. So it's hard to say at this point whether the numbers have been affected. Have been affected from last year, yes. But when you look overall, it's hard to say at this point whether this deterrence strategy is working. Another effect has been that it's been much more difficult for children and youth to access humanitarian relief. I want to throw one number at you, which is that because there's no right to counsel for children in removal proceedings, you see a dramatic difference in how children with lawyers are able to access relief. And this has become particularly pronounced under the Trump administration. But for children who have lawyers, which they're able to get if the court gives them more time to get a lawyer, usually, if they have a lawyer, then 80% of the time they're able to find some humanitarian relief that allows them to stay in the United States. For those who don't have a lawyer, 16%. And it's not because the lawyers are cherry-picking the good cases. They're assigned lawyers as the case came in. It's pro bono lawyers. They'll usually take cases as they come in. And that has become particularly intensified because they're trying to make these cases go faster. It's harder for children to get attorneys, and so that difference is becoming more and more I'm going to stop, but I'm happy to answer any questions when the Q&A time comes.
So it's hard to know even where to begin, given everything that is happening on an almost a weekly basis, if not a daily basis. But before we jump into the issues surrounding refugees and the travel ban, I wanted to start by mentioning that immigration is a unique area of law. And in immigration, Congress has plenary powers overall, meaning that Congress has the ability to do an immigration law, legislation that would be impermissible in any other area of law, and that many of the things that you've learned in constitutional law will not apply to immigration law. And you need to understand that coming in, because otherwise your conversation and your understanding of the issue will be totally different. You should understand, though, that there are some, so that plenary power has been given to Congress. It has not been given to the president, although there are, of course, there are delegations of power that can happen, which hopefully you guys have looked at that in administrative law and other areas of the law. Refugee processing is given to the president to decide, however. So most of you know that I run the asylum clinic. There's a lot of confusion between people with asylum and refugees. And I want to clarify this to start with. Both asylees and refugees have to fit the same definition, which is that they are people who've been persecuted or have a well-founded fear of persecution on account of race, religion, nationality, political opinion, or membership in a particular social group. If someone makes it to the United States, if they get into the United States or they get to the border of the United States, they can apply for asylum. There are no numerical limits on asylum. So as many people as can make it here can attempt to get asylum. Refugees are people who have been adjudicated to be refugees to fit that definition overseas, and there is a number of them that we agree to take in and bring over. We are not the only country that does this, although the United States is the leader in terms of the number of refugees who we bring in. But there are millions more people classified as refugees than are resettled in countries as refugees. So asylum has been affected post the Trump administration. There are several ways in which that has happened. So there are new regulations and guidelines for what's called credible fear, which Emily will talk about a little bit. There's definitely increasing hostility towards immigration attorneys, particularly asylum attorneys. And I don't know how many of you watched Jeff Sessions' speech, but I actually got a t-shirt in the mail today that says "Dirty Immigration Lawyer" on it. But refugees have been impacted much more. So the first executive order, which included the travel ban, also cut in half the number of refugees that the United States accepted. So it essentially, Obama had said that I think it was 110,000 refugees would be allowed to be resettled into the United States, and it was cut to 50,000. With all the litigation around the travel bans, the refugee numbers are cut, because the president has the right to set those numbers, and that is what Trump said. And so when we hit 50,000 refugees, the day that we hit those, the United States stopped accepting refugees for the year. The number announced for next year is 45,000. And again, in terms of the number of refugees who can come in, by regulation, it is the president who sets that number. So therefore, that has happened. And I think that very few attorneys believe that there is a way to effectively challenge that to try to get more numbers in. We have, so that's the refugee portion. The travel ban, I feel, as I was thinking about this yesterday when I rewrote everything I was going to say. Actually, I didn't rewrite it because it was late and a 40-page decision had come out, so I was scribbling notes on the sides. And then I came in today and the other decision came out, and it's 90-something pages, and I teach from 10 to 12 on Wednesdays, so very little is written out. I thought that what I should have done is drawn a flow chart, because there's really very little ways to look at this, although in addition to the actual law, which we will talk about, that is involved, it is really interesting to look at this to see it as lawyering on both sides and the way different motives are being attempted by both litigants or all sides of the litigants in this legislation. So the first travel ban was issued in January 27th. It was an executive order. It temporarily suspended refugee processing. It suspended entry of people from a list of Muslim-majority countries. It was initially thought, how it is written suggests that it included barring legal permanent residents from entering the United States. So legal permanent residents were in the beginning barred from entering the United States. If you live in New York, you probably know some of the things that happened. Lawyers flooded the airports. Many of my students and myself were at the airports. Cases were immediately filed throughout the courts in the U.S. Temporary injunctions were issued at that time, enjoining the order from being enforced. And this was an interesting thing to watch which injunctions were nationwide. An injunction was issued that was good, but it covered only a certain area. So suddenly the immigration attorneys were all on the phone saying, change your flights, fly into Boston, and this is part of being an immigration attorney. A national injunction was issued. So now you had cases you had a whole bunch of cases actually, but the two ones that moved the fastest were in the 4th Circuit and the 9th Circuit. So the injunctions went up, they went up on appeal to the circuit courts. In the meantime, a new executive order was issued, which replaced the first executive order. And this executive order made clear that legal permanent residents were not included. It still had a temporary suspension of some of the refugee processing, and certain people from certain countries were targeted. Complaints were amended to include the second one because the first one was now moved because a new executive order had been issued. The second executive order, most of the suspensions were temporary. They were set to expire after 90 days from implementation. After the circuit courts upheld the injunctions, now keep in mind these are not the merits of the case. This is just whether the executive order is enjoined while the cases are ongoing. Went up to the Supreme Court. So the Supreme Court on August 10th issued its decision on this case, which was, this is moot. It's expired at this point. So go back down to the circuit court so it can be dismissed because it's moot. And in the meantime, a new executive order was issued. And that is the executive order that's in place right now. Now, what's actually issued is a proclamation. What's a proclamation? You guys know what a proclamation is? I actually went to my books to say, all right, it's a proclamation. What is a proclamation? I'm not really sure. Essentially, it is the same as an executive order. There are a few theoretical differences that an executive order is usually considered to be stronger than a proclamation. An executive order may be aimed at the federal government, whereas a proclamation tends to be aimed at the general public. But apart from that, they're very similar. They have to be published in the Federal Register. They can be challenged in court. In the impact of them is almost identical, although it was interesting to me to think, why wouldn't they have made this a proclamation rather than calling it an executive order? But, so the new executive order banned individuals from 8 countries, and this is an indefinite ban, so there is not a kind of sunset provision on this. And the countries affected are Chad, Iran, Libya, North Korea, Syria, Venezuela, Somalia, and Yemen. And within those countries, it's a little bit different. So for some, everybody is banned. For some, everybody except students are banned. In Venezuela, family members of certain government officials and then government officials are banned. So it's a little different within the countries. This went into effect immediately for people who didn't have a bona fide relationship with somebody in the United States, and went into effect today for people who do have a bona fide relationship with people or an entity within the United States. It is possible under the new ban to apply for a waiver of the ban if you can show that there would be extreme hardship and that the interests and the national security of the United States would not be affected. So yesterday, a decision came out of Hawaii, which struck down it did not strike down. It issued a temporary restraining order, and it is, again, only the restraining order that is issued. And what the court in Hawaii said, the reason that they issued it was that they said there is a section in immigration law that allows the president to make certain findings about the interests of the United States and then stop entry of people based on those findings. And the court found that the administration had not made those findings, that they had thrown some findings in, but not the level of findings that the Ninth Circuit required to be made in this case. So essentially they're saying, you're banning these people because you're saying security of the United States, but you're not showing the required relationship between your action and the interest that you are showing. This morning, another decision came out in Maryland, and this court kind of made a wider decision. The court said, first off, that the President's Act violates the non-discrimination provisions within the INA, which says that you should not discriminate on the basis of nationality. And they said that's what you're doing here. And that provision that allows the president to, I do see you, Jen, that allows you to, suspend entry still incorporates the non-discrimination provision. So you cannot discriminate in terms of your actions under that statute. And they also say that it violates the anti-establishment clause, that essentially that it is an attempt at a Muslim ban, as opposed to the stated purposes in the proclamation, and that violates the establishment clause. So these are temporary injunctions. All that means is that while the cases are being challenged, it will not be enforced. There's actually a little carve out of some things that can be enforced, and really everyone in North Korea and Venezuela, since so few people are impacted. It will go to the circuit courts without a doubt, and it will almost certainly go up to the Supreme Court. And in the meantime, at first it will go up challenging the temporary injunction, because that's huge, right? During the years that it will take to review a lot of these cases, will people from these countries be able to enter the United States, or will they be kept out? And after it goes up and down on the temporary injunctions, it will go up and down on the merits, if not on several other grounds. So I will hand it over to the next speaker.
Hello. So I'm going to talk about the removal side of things. Technically, the legal term is removal, not deportation. I'll try to use those interchangeably, but I just wanted to put that out there. I think I'd also like to give a couple of definitions before I start. Immigration attorneys, as all attorneys, are very prone to using acronyms, and so I'm going to do my best not to do that. But one that I am sure I will use is ICE, which is Immigration and Customs Enforcement. It's sort of the police branch of the Department of Homeland Security. And they're the ones that are responsible for apprehending individuals, detaining individuals. The Office of Chief Counsel prosecutes cases in immigration court, and then enforcement and removal operations are the folks that actually send people out of the country. To start, I'd like to talk a little bit about priorities. There are 11 million approximately people here in the United States who do not currently have immigration status. The Obama administration recognized that the executive branch has had a great amount of discretion in determining who to be targeting for removal, and they decided to issue a very explicit memo outlining their priorities and how they were going to spend their resources. And that included, as you may have heard, felons, not families. While yes, it did include people who had criminal convictions, but it also included recent immigration violators, meaning people who entered the United States after January 1st, 2014, and also repeat immigration violators, so people who were removed and then had re-entered. And so during the Obama years, the majority of the removals were happening at the border, people who were apprehended there shortly after entry. The Trump administration sort of threw that memo out the window and said, no, everyone's a priority, but there are certain extra priority people, and those are folks who have criminal convictions, but they're also folks who have criminal charges, and folks who are suspected of having committed crimes. And so that's a departure from the Obama administration, who were really concerned with people who had actually been convicted by a court of law. And how we're seeing that change in priorities play out is an increase of ICE presence in criminal courts, picking people up, whether or not their cases have been concluded. So you see people picked up at arraignment, people who come for various hearings are being picked up, and ICE does not then allow them to continue defending themselves in criminal court, so bench warrants are generally issued, and if they do manage to get out of ICE custody, they will then likely be rearrested by the local law enforcement. We've also seen a return of Secure Communities, which is a program, it's an information sharing program between local law enforcement and ICE. When someone is taken into custody by local law enforcement, they're fingerprinted. Those fingerprints are run through several databases, including the FBI database, to see if there are any outstanding criminal issues in other jurisdictions. And the FBI automatically shares that information with the Department of Homeland Security, who will then run their own checks and decide whether or not this person is someone that they may want to detain and attempt to remove from the United States. And so once they've made that determination, they will send what is called a detainer to local law enforcement. It's sort of styled as a demand, although there's been quite a few courts that have found that they're actually only requests, otherwise it's a violation of the commandeering clause. But anyway, it says, please hold this person for up to 48 hours after you would otherwise have released them, so that we can come and pick them up, because we have reason to believe that they are removable from the United States. So that means that when someone is released on bail, is released after having served a sentence, or is being released because the charges against them have been dropped, those folks are being held for up to 48 hours for ICE to come and take custody of them. Folks on Long Island are processed through Manhattan, and then they are sent to a variety of jails that ICE has contracts with, mostly in northern New Jersey, but there is one facility up in Orange County, New York. It used to be, when people were taken into ICE custody, that unless ICE determined that they were subject to mandatory detention, or there was some very good reason not to set bond, they would set a bond amount for that individual. And they were generally fairly high bond amounts, but there was a bond set. So if they could afford that, they could pay it and be released to go through their removal proceedings, not locked up, which is a much slower process and provides a lot more opportunity to develop your claims. We've seen that stop. So ICE is not generally setting any monetary bond for individuals that are being taken into custody. And they are taking people into custody who, prior to the new administration, would not have been held at all. They would have been processed, issued a notice to appear, and then would have gone to immigration court on the non-detained docket. So what that means is, these folks have an opportunity, they have a right to have their custody reviewed by an immigration judge. They can ask for what's called a custody redetermination hearing, where the judge will consider flight risk, dangerousness, and if they decide that this person is not a danger to the community or a flight risk, they will set a monetary bond. That process does take time. We've been seeing it take probably about a month and a half for people's notice to appear, which is the document that sort of initiates immigration proceedings, to be filed with the court. You can file a request for a custody redetermination before that, but it still takes about 2 weeks to get before a judge. So people are being locked up for considerable amounts of time. It's also been a pretty big challenge to get people out on bond. They have been interpreting dangerousness and flight risk very broadly, at least in our experience in the New York detained court. So the other thing that we've been seeing are gang sweeps. And as we know, Trump came to Long Island and talked about what a huge problem MS-13 in particular has been here. And that is certainly accurate that it's a problem. However, we are seeing a lot of people being swept up in these gang raids. And generally how it's been happening is the local law enforcement, either the Suffolk County Police or the Nassau County Police, will team up with ICE. They've been going to locations that are known gang hangouts, bodegas, restaurants, bars, that sort of thing. They're going in, they're asking everyone for identification. The police are arresting anyone for any criminal matters, and those who do not have criminal matters or other issues that local law enforcement is concerned about are then sent out to ICE, and they're taken directly into ICE custody. And if you're accused of gang involvement, it becomes very difficult for you to get bond because they think the gang members are a danger to the community, which would be accurate, I think. However, the grounds for finding that someone is a suspected gang member are very broad. So for example, the list of things includes wearing certain colors, hanging out in a place that's known to be frequented by gang members, associating with someone who is a gang member, making certain hand gestures. And so we've seen a lot of people who have no gang connections being picked up. If you have 2 or more of those factors, then you are considered a suspect gang member. And so that's been a challenge. We've also heard stories, particularly in Suffolk County, of schools suspending students and sending ICE a list of students that they believe are gang members. And ICE has been picking those high school students up and detaining them. And for a while they were being sent to high security facilities in California and Virginia. So that's been a subject of ongoing litigation. The ACLU has been working on that. So that's sort of what we're seeing in the detention and removal side of things. One thing I also wanted to cover was some of the executive memos that have come out and what exactly they are trying to do. So some of it's been covered, but there was certainly an executive order about the border wall, ordering 5,000 new Border Patrol officers, 10,000 more ICE agents, calling for the increase in criminal prosecution of people for federal crimes such as illegal entry and illegal re-entry. And so those are things that have been going on for quite some time, but they want to start increasing the number of people that they're prosecuting criminally. And one of the ones that has most concerned me is the suggestion that they're going to be expanding the use of expedited removal. Expedited removal is a section of the Immigration and Nationality Act which allows them being ICE or the Department of Homeland Security, to summarily remove someone who entered without inspection, for example, or who has a false claim of citizenship or has used some fraud or misrepresentation to enter the United States. Those folks do not have any right to see an immigration judge. There is no right of appeal generally, and they are summarily removed, and they are not eligible to re-enter the United States lawfully for at least 5 years. Currently, there is a regulation which limits the use of expedited removal to folks that are apprehended within 14 days of entry and either at the port of entry or within 100 miles of the U.S. border. The memo that former Director Kelly issued in February said that they are looking into promulgating new regulations to expand the use of expedited removal. The statute, as currently written, would allow them to expand the use to anywhere in the United States and for individuals who are apprehended within 2 years of entering the United States. So it's a huge expansion of who might be subject to expedited removal, and in doing that, a lack of due process and an inability to apply for most forms of immigration relief. The only way to sort of stop an expedited removal is to express a fear of return and request a credible fear interview. And that's where the individual is interviewed by an asylum officer who will make the determination whether or not this individual should be allowed to apply for asylum before an immigration judge. And so that is what Attorney General Sessions was speaking about when he talked about magic words that dirty immigration attorneys were giving to their clients. So that's sort of, in a nutshell, what I wanted to talk about, and I'm happy to take any questions during question time.
Staying there.
Unless we're leaving police or something.
What I'd like to talk about is legal strategy, lawyering strategy to tackle some of the issues that the other three panelists talked about. When President Trump issued his executive order establishing the first travel ban earlier this year, immigration advocates were thrilled with the quick impact litigation that was filed by the ACLU, by the state of Washington, and the initial court victories in those cases. There were celebrations in the progressive community about how federal courts were going to be the saviors for our system. And it reminded me of the civil rights victories in the 1950s and the 1960s in federal court, when progressive groups focused their energy not as much on the political process, but on federal courts as the venue for challenging violations of constitutional rights. At that time, the federal courts were heralded, as they have been the last 9 months, as the one way that rights can be protected. And actually, one of the reasons that I went to law school, that I was inspired to apply to law school in the early 1970s, was because of this mindset that the federal courts, the impact litigation, was going to be a way of changing society. The first comment that I wrote as a second-year law student for law review was on class actions, about notice requirements in class actions. And I, in that article, sang a paean to class actions as the great legal strategy for changing society. And my editor, Ray, I can still see him now, Ray Bemis, he looked at me and he said, wait a second, think of the other side. And he started to get me to think about some of the disadvantages of class actions. And Larry was a bit prescient because starting in the 1980s and up to the present, in the last 2 decades, there's been quite a number of critical law pieces, law review pieces, on the limitations of impact litigation, of class action litigation, as a mechanism for law reform. What I'd like to talk about today is the implication of that scholarship for impact litigation on immigration issues. The scholars who are critical of impact litigation raise a number of arguments. First, they argue that the use of legal doctrine, what you guys are being indoctrinated in day in and day out, as a way to produce law reform, constricts a client narrative to a legal theory. In other words, disadvantaged clients are placed in an alien legal straitjacket. A client comes to you, or you have an idea about why the client has come to you, and then you develop this very complex legal theory to respond to it. From just a PR standpoint, technical legal theories might be compelling to courts. It might result in some great decisions, but in terms of long-term political impact and to just the general public's response, it may have very little impact. Moreover, the procedural technicalities of much impact litigation. Professor Wren continuously laughs at the decade-long saga of some impact litigation I brought, my clinic brought, for immigrants in 2006, and how long it took to get the result that we wanted. There's class certification, there's complex motion practice, there's prolonged discovery. The cases become divorced from the actual stories of the client, from why the client initially came to you. Second, a related argument against impact litigation is that it focuses solely on the stories that lawyers tell. The legal theories leave disadvantaged clients as bystanders. The clients become irrelevant. The idea, the constitutional theory becomes the important focus for the lawyer. The first class action which I ever was involved in, and I was a lowly third-tier lawyer on it, Edelman versus Jordan, it was a 11th Amendment Supreme Court case. It was a class action. It wended its way twice to the U.S. Supreme Court, and years after it was filed, there was a settlement. And the lawyer who was in charge of the case couldn't find the client who agreed with the settlement. And we spent days trying to track this person down to tell you actually won a case, which he didn't know that he had. Impact litigation has this way of becoming kind of the lawyer's game rather than focusing on what the client wants, what the client's interests, underlying interests may be. Finally, the argument is that even when successful, impact litigation doesn't necessarily have lasting results. Without political strategy, any victory can be undone. There are plenty of cases in which there have been fantastic consent decrees, where there has been, after class actions, a great victory, and over time it's whittled away through either the legislative process, through neglect by the lawyers who had the victory and went on to other things, or that the executive branch has been able to undermine. The bottom line of this scholarship is that clients have stories to tell. There are interests that are involved beyond just legal theories, and that lawyers in courts sometimes stifle the telling of those narratives. All of these factors, I think, are important in immigration advocacy. Of course, there is a need for temporary restraining orders to remedy immediate dangers which people face. But if there's going to be a long-term political effect, that just focusing on these complex theories and procedural maneuverings in court may not actually have the effect in the long run that folks want them to have. So, what are my recommendations for how we deal, how progressive lawyers, public interest lawyers, deal with impact litigation in the era of Trump? First, I think our mindset has to be rushing to federal court may not always be the best strategy. Getting those class certification motions and trying to get your one client that you can bring as a named plaintiff may not be the answer. In those few heady days after the travel ban was issued, the impact case in New York was extremely effective. It sought, as Professor Renz described, it sought a quick TRO and was brought in conjunction with just fantastic lawyering by Professor Wren and hundreds of lawyers such as her, such as she, at JFK, at other airports, representing folks who needed help. But at this point, the cases have become non-common court. There's been maneuvering by the Department of Justice, there's been maneuvering by President Trump. There were 2 victories in the last 2 days for immigrant advocates. But down the pipe, is there going to be? That's the question. So here's some specific recommendations that I have. First, I think that lawyers that are immigration advocates need to take a minimalist approach. Not some sort of complex legal theory, but actually a theory that people out there, the public, can understand. A simple theory that syncs the legal theory with what the client community wants. A good example of that is a case decided by the Massachusetts Supreme Judicial Court, Lund versus Massachusetts, in which the plaintiffs in that case challenged local law enforcement cooperation with ICE in other words, police enforcing ICE administrative detainees, what Emily talked about a few minutes ago. They didn't bring some expansive Fourth Amendment constitutional challenge. What they simply did was to base the case on Massachusetts statutory and common law prohibiting arrests when the police have reasonable cause to believe a crime has been committed. The law in Massachusetts is clear, as the law in New York is, that police can only arrest when there's been a crime, a felony or a misdemeanor has been committed. And so what the challengers in that case argued is that you're actually, by arresting in response to an ICE detainer, is violating the simple tenet of Massachusetts law. As a result, and the Massachusetts Supreme Court, Supreme Judicial Court, quickly, without months of procedural wrangling, but very quickly decided that for the plaintiffs in that case, as a result, there's been relief, and there's been a relief without the need for years of litigation. Secondly, when bringing a case, I think it's very important that lawyers make sure that there's a compelling story to tell. That in many ways the clients present the case. The clients have been hearing. The clients are collaborative with the lawyers to come up with a story to bring. ICE action against a sympathetic client with a loving family, with stable ties to the community, with a real powerful impact in the community. For example, immigrants that are fighting those gangs like MS-13. To be effective in the long run, we need more than a court opinion, pages and pages of opinions as a technical legal issue. What we need is a story that not only will have a legal effect, but that will actually have an effect on the public who will understand the story of the client that's being told. And finally, to be most effective, impact litigation should be tied to a political strategy with community groups. This has been my song for a number of years now, that if you're going to have impact litigation, you have to have it hand in hand with a political strategy. Right now, a deportation defense clinic is working with Grayson, a Long Island immigrant advocacy group. They're working on public education. They're working in trying to organize religious and civic groups and press conferences, protests. That's hand in hand with some litigation that I can't talk about right this second, but because it's percolating, it's in the works. But we will be doing the Deportation Defense Clinic and the Law Reform Clinic. Together we'll be doing these cases, but at the same time, the story is going to be told on the streets as well, with religious and civic groups supporting it. Now, you may say, after hearing me, that Trigger, you are director of a law reform advocacy clinic, and here you are giving the gospel, presenting the gospel against law reform litigation. Well, in some ways I am. I'm saying it's limited. That when we see on CNN, when we read in the papers all about these court victories, that we should understand that if we really are going to have an impact besides a 6-month victory against the Trump administration, then what needs to be done is to develop both a political, legal strategy to get the goals that we want to achieve. Thank you.
So it's always a pleasure to moderate a panel of folks who their time deadline. And partly that's because we have a room full of people who may really have burning questions that you want to ask. And so if you want to raise your hands, I'm happy to walk around if you have a specific question, but I'm going to take it, and while I give a moderator's opportunity to ask a first question, raise your hands and I will begin to walk around the room. But here's my first opening question. So if you think back to what I said about Justice Sotomayor's comments at the outset about the importance of being able to have civil discourse in this country, particularly on questions of immigration that are so important to us as a country. I'll start with, are there any areas where you believe that we can actually find some consensus, given that it seems like there are very extreme positions on both sides? And maybe if any of you want to give us a little prediction about whether you think that Congress will be able to get it back in gear and do anything, or whether you think there are areas for those of us in the country who long to find some consensus on this issue. Is there any hope for us to do so, or are we just going to continue to be at extremes? And I'll pitch it to whoever wants to take an opportunity to respond. And if you have a question, raise your hand.
I'll go ahead. Is this on? Yes. So this might be rose-colored glasses, but I think that there are at least two areas where there might be a lot of common ground for people who believe that, or come from different ends of the spectrum in terms of immigration. One is, I think it's fairly universal that our system of immigration enforcement in the courts and outside the courts is not done efficiently or effectively right now. There are incredible delays in the court system, for example, which causes problems for individuals who do have legitimate claims to immigration relief. So I think, and I think part of Trump's executive orders were to have more immigration judges hearing these cases. So I think that's probably one area where you would have maybe not consensus across everybody, but fairly broad consensus. The other, and this one I'm less sanguine about, but I would be hopeful with my rose-colored glasses that there could be some consensus, is that individuals who actually do qualify for humanitarian immigration relief will get that relief. We have a number of laws in place which are quite compassionate, whether it's for victims of crimes or individuals who've been trafficked or survivors of domestic violence or abused and neglected children. There are laws that are in place. And I would hope that most folks across the spectrum would think that if someone qualifies for relief under those laws, that they should have a chance to present the evidence in support. Now, what that actually ends up meaning is more questionable. For me, that means a right to counsel. That's what you need in order to present evidence effectively. I think there would be a lot of pushback on that idea because it, of course, costs money to file counsel. But those would be the two areas where I would be somewhat hopeful of some consensus.
I'm going to snicker at you over here derisively there. There is definitely an idea of get more immigration judges through there, but with a elimination of many of the protections of due process, with the idea of let's deport people quickly. I think there is not a sense of let's get people the benefits they deserve more quickly. I think also that I agree that many of our laws are good. I think that we are in a hostile environment for those laws, and that there will be repeated attempts to change, to not enforce them, which we're already seeing correctly, and to repeal it. Certainly, within asylum, it was part of the Republican platform for the presidential elections to eliminate the social group. which would eliminate provision for asylum, which would eliminate asylum for LGBT people, it would eliminate asylum for survivors of domestic violence, it would eliminate many of the children fleeing gang violence from Central America, and there are repeated attacks, I think, going on our most basic humanitarian relief. Although I would add that refugees have never been welcome in the United States, in spite of our rhetoric and in spite of my, longing for the United States to be a place that welcomes refugees. The majority of the public has always been against most refugee groups coming in. Our refugees laws were, based on international agreements, which were passed after World War II, when the United States felt a lot of shame for having sent Jews back to Europe when they were trying to escape Nazi Germany. But that if you survey public opinion usually is against admitting refugees. And there's constant talk by people in the government, like Sessions recently, but other things that talk about, oh, they found a loophole. Well, it's not a loophole if it's the Refugee Protection Act. That's a specific law that's meant to protect them. Or, they're breaking our laws by coming here. No, actually, the law provides that they are allowed to come to the border and apply for asylum. They are not breaking the law by doing that. Our law gives them that right. But we're seeing on our borders people being turned away and not allowed to apply for asylum. We are seeing increased detention being used to stop people. If we keep you in jail for a year, will that discourage you from coming and applying and other things that are not merit-based to try to prevent people from
So Professor Wren, am I hearing you say that you have no hope for there being any cause for any middle ground or consensus?
I would say that there's a very big difference between middle layers of enforcement and upper layers. So depending on where you are in the United States, the middle layers, I think, are often people who believe in the ideals of the program, so that not so much in the detention facilities, but in the courts that I practice in New York City, many of the attorneys who work with the Department of Justice are trying to do what's right, and the judges also are trying to fairly adjudicate the cases. I do not have hope at our higher level during this administration that we will reach agreements.
Okay. We have a question over here.
Thank you. My name is Suleiman. I'm an LLM student. I'm from Namibia. This is a topic very, very close to my heart because I am from abroad, an immigrant maybe. I would like to start with a comment that it is really alarming that after so many years, a nation that was a beacon of hope to the world is finding itself in this position. We expect so much from the U.S. and it is quite a shame that the president is reversing the progress that took so many years to get here. My question is directed to Professor Lawrence. You said the president wanted, you said the president violated the non-discrimination provision. I would like to know what is in place to hold the president accountable. What has the nation done to hold him accountable for violating that provision? Thank you.
Sure. The court, that is the finding of the court in the Hawaii court found that he had. The lawsuit is not an attempt to hold him accountable, and in terms of the courts being able to do that to the president, like that's a very limited ability. It is to stop the enforcement of the travel ban. So in terms of what has been done, it's gone to court. Right now it is temporarily banned, and that is essentially the extent of what has been done.
So I actually know that we have a few, at least, clinic students here in the room. And given that you are all clinical faculty and have your boots on the ground in varying ways, I was wondering if you could maybe each take a minute or two to talk about, or give your students in the room an opportunity to talk about what they're seeing as far as their clients' experiences, or anything that you wanted to share. I'm happy to, if you raise your hand if you're a clinic student and you've been working on any of these cases, just raise your hand if you want to talk.
But don't you dare give away confidential information.
So it says you're a physics professor, right?
Hi, my name is Erica Adaman. I graduated last semester. So I'm not a clinic student, but I was a youth advocacy clinic student. Right now I'm working at an immigration firm that's basically doing the exact same thing that I did in clinic. So I work with special immigrant juvenile status. And so what I wanted to say is also directed at Professor Liebman, is that although there are some humanitarian relief for these children, it seems that the end result isn't really there. So there's a waiting list, well, sort of a waiting list, waiting for it to become a priority date, where these children are in a weird limbo. They used to be able to get employment authorization, now they don't. So have you heard any rumors, or did you hear anything about these kids potentially getting their residency at the end of their process? For now, what I hear is that the priority date is still in 2015, and some attorneys are saying that this list could even continue to have these kids in limbo, and some kids might even wait up to 10 years. And so, you know, this puts them in a really tough position as an attorney, or potential attorney, I'm sorry, to recommend this avenue for children and then not being able to follow through with it.
So the SIJ is the Special Immigrant Juvenile Status, which is a pathway for children who've been abused, neglected, or abandoned. And it used to be that when you filed that petition, you could also apply for work authorization and even legal status, and those would be processed together and much more expeditiously than they are now for children from the Northern Triangle countries. Now those children are on a wait list, and actually the processing has slowed for all children as well, even though there's no official wait list. So that's been a big problem, especially for clients who start to get to an age where they are graduating from schools and would like to be working, etc. There is no indication of when and if that process is going to speed up. That's been a big frustration for children and youth who are trying to access certain forms of relief. But I will say that the 2-year waiting list that you're talking about, or about 2 years, it's very unsure how long they'll actually be, is still far less than things like U visas, which is for victims of crime, which is about a 10-year waiting list for those individuals. And a lot of those waiting lists, to be frank, grew before the Trump administration. Although the SIJ thing is relatively new, a lot of those wait lists were in play, or backup was in play before Trump took office.
And the wait list is actually governed by immigration law that has been in existence for a long time. And the reason that there's a bigger wait list now than there was before is because there's so many more kids from these countries. It's a numerical limitation, and it's not a lesser, it's not like refugees where there's a lower number now allowed in. It's just that there's so many more, that there is a wait list as opposed to being an administration thing right now.
So I'm Robert. I'm in the asylum clinic, actually. Just when Professor Gundlach asked to speak about some of our experience, I think in the asylum clinic we're a little bit luckier because there is some protection there, with asylum being separate from the knee-jerk reactions that happen within immigration, and it's been kind of been ignored to a degree. Of course, we have certain things that have gone in, such as the 1-year filing deadline, which we found out didn't exist until relatively recently, and would be great if it didn't exist anymore.
Yeah, so they're way before Trump. It's been
Yeah.
in existence for 17 years or so.
But I will say, speaking to Professor Liebman's point about people coming from El Salvador and things like that, there are tons of our clients in the asylum that are in El Salvador. And it is racked with gang violence. You almost become, like, it almost becomes like a recital that you have. It's like, okay, attacked by gangs, attacked by gangs, attacked by gangs, things like that. And you see people with really, really horrible stories. And they've come to America and they've taken such great risks to come to America. And then to have to look at them and say, I'm sorry, your story is just not quite terrible enough for you to get asylum, is incredibly hard for us. And we have some clients that we're having to work through that and really dig at their stories for. So I would highly recommend, though, if anyone is considering the clinics, absolutely do a clinic, particularly because we have so many great immigration clinics. And you can really, it's one of the areas where you can really feel like you really impact and help, and you can actually see the impact that you have on somebody after you've gotten them asylum or after you've saved them from deportation or something of that nature.
Thank you. Thanks for the panel. Lots of valuable information. I guess my question kind of taps to what Professor Krieger said, which is in essence that most of what you're saying or the information that you're talking about is quite outrageous, and what's happening to those people is very outrageous. And your stories are not personalized. Imagine if these stories are peppered with the real stories of those people, and that actually comes out with a very devastating view of what's going on in this country. I guess my issue is why is it easier for the Trump agenda or for the extreme right-wing agenda to show their stories in a way that's more appealable to people or easier to understand by people, whereas your story or the story of the victim's story is not being reached to other people? Where is that loss in messaging or to the communities in the United States? And why aren't people outraged by what's going on in the immigration community?
I think your question is great in terms of how you frame the issues. And I think, going back to the question of Justice Sotomayor's comment the other night, that we have to find a way to be able to confront the fear of the other that, and it's not just the right wing, but a good deal of the public has. And I think one way of framing it that does appeal is, this will sound kind of wacky, but think about it, is as a religious issue. That if you think of some of the strongest immigrant advocates, it's across the board from the Catholic Church to some mainstream, even Orthodox Jewish congregation, certainly from the Islamic community, even evangelical Christians. And if we can frame the protection of those immigrants that tell the stories within those communities, religious communities, I think that we can have some sort of impact. From my own experience with a little group on the Upper West Side, that we have been able to get Orthodox Jews who never would have been part of some sort of progressive organization involved with these issues because they can relate it to the values of their faith background. So I think that one of the challenges we have is how can we frame this to reflect values beyond constitutional rights, due process, right to counsel, to the right of folks to be able to live productive lives consistent with the values of our faith.
Any other questions?
Hi, good afternoon. My name is Angelo Lagman. I'm an international 1L. Just have 2 questions, I'm sorry. So first, would you please be able to give your thoughts on the constitutional protections for non-citizens here in the United States? And my next question is, with a proposal of the RACE Act, with Senator Tom Cotton from Arkansas, what do you think are the implications of that for the future of immigration law? Thank you.
So, the
Doris, can you
first,
pull the mic closer?
the first distinction that I'd like to make is the distinction between the treatment of immigration law and the treatment of immigrants. So within the United States, most constitutional protections apply to immigrants. Like you have either you are not allowed in most situations to discriminate against immigrants, and constitutional rights apply to them. It's immigration laws that there are plenary powers. So in terms of what could Congress do to restrict who's allowed to enter, what are special rules that relate to immigration itself. But could there be, there have been cases about special taxes on immigrants. Well, no, that's not, that's tax law, that's not immigration law. That would be unconstitutional in terms of a lot of the treatment. So I don't know if that has answered your first question, but within the United States, immigrants have constitutional protections except for those rights that attach only to U.S. citizens. But most of the protections, and including non-discrimination protections, apply to everybody. And by the way, that applies to undocumented immigrants as well. It's unless there is a protection that is specifically limited, it applies to everybody within the United States. So, is anyone? Okay, with your second, do you have a specific question about beyond? So on the your second question that you were asking, I'm not sure if there's a specific question or if it's just a question of, what are your thoughts?
What are your thoughts and implications on the future of immigration law in the United States?
In general, American public opinion on immigration is favorable. That's apart from refugees, by the way. But most people want immigration reform. Most people, when there's public polling, want people who've been here for a long time to be able to get status. And my long-term hopes for immigration law is that when we get past a lot of the hostilities we have going on right now, that we will have laws that reflect what people think, as well as the protection of fundamental rights for people. I think right now there is just a lot of hostility. There's a lot of hostility based on religion, a lot of hostility based on race. I think there's a lot of hostility based on there being an increasingly diverse population, so white people losing the majority, and that has always affected our immigration law hugely. Race has always been a huge part of our immigration law. I'm very worried about what the next 3 years could bring in terms of immigration law, although I also think that there's enough discord that anything that requires an actual law passing as opposed to an executive action, there's a pretty good chance that it won't happen. I don't think there's any immigration law that would pass right now that I would consider a good law.
My name is Rosanna Parati. I'm a professor in the political science department, and I am teaching for the first time a course on U.S. immigration policy, learning at the same time some things. Is there a clear articulation in the law of the difference of where states' powers end in this area and where they may not tread? And I'm thinking about the idea that there are localities that are sanctuary localities, and on the other hand, there are localities that assert that they want to punish employers of undocumented immigrants and people who rent to undocumented immigrants.
Should I jump in? Okay. So immigration law is federal, and it actually is not specifically granted in the Constitution, so there is, of course, a long-standing debate as where that power comes from, because if it's not an enumerated power. However, it is very widely accepted now that it is a federal power through case law, and any state action that is seen as encroaching on that federal power is struck down. There have been cases involving areas of law that are considered local, say, licensing rules or habitancy rules that seem to some of us to be directed that the purpose is immigration law. And some of those have been struck down, but some have been upheld, with the court saying, particularly there's some in Texas that have been upheld by saying, no, this is a traditionally local province, they can pass law, the state can pass laws about that. And things like licensing and, the sanctuary city issues, that will be wildly litigated, I believe, and I think there is law on both sides that can be pointed to. Certainly, there is plenty of law essentially saying that the federal government can't require a state government or local government to have their police enforcing federal law. And there's law that says, well, and if you punish them through granting of other money, you're essentially doing that. But there is some case law on the other side as well. Is it clearly stated? It is. Is it clear how the indirect applications of it will be treated in court? I don't think it's clear, although I think lawyers expect it to go different ways and have an idea of how it will go in different types of cases.
Any other remaining questions?
You have to get it. I'm Debbie Grattan. I work with Professor Yaroshevsky at the Moreau Friedman Institute here. And I just had a specific question about DACA right now, in particular for the young people who have that status. Well, I know we can talk about particular cases, but in general, what are lawyers recommending they do right now? And I'm also, I've heard obviously a lot of concern because these young people, many of whom have made decisions with their family, have now exposed their parents and their legal status. So I'm just in general wondering what lawyers are recommending these DACA recipients do right now.
Yeah, so for up to October 5th, individuals whose status was going to expire before March 5th, it was to get a renewal. So you have an additional 2 years of status. But in terms of longer term, or for those individuals who didn't fit into that criteria, to be screened again, if you haven't already, do it for the first time, to see whether you're eligible for any other forms of immigration relief. In terms of the concern for your family members, that's a very valid concern. The government has that information. They have said, and when DACA was initially enacted, there were promises that that information would not be used for enforcement purposes. If I were in that situation, I don't know how much I would count on that, but that was a different administration. But supposedly that information is not going to be used for enforcement purposes. And then a decision has to be made by the individual on whether they want to remain in the United States, have status, or they want to return to a home country that they probably do not know since they came against you.
Although this is actually part of a narrative that is not totally true, but it's an example of how narratives pick up. In the DACA application, there were no questions about parents or parents' location. You didn't put your parents' name, you didn't put your parents' location. You know, sometimes people may be living with their parents, so they may think, but many of our DACA people aren't living with their parents, and immigration is so inefficient at tracking people down anyhow. The idea that they're going to jump from, but this is a narrative that went up around the DACA was, the kids are innocent, it was their parents who brought them here, and that was what was being pushed when people were trying for the legislation. And more recently, that has turned within the immigrant community to, are you betraying your parents by blaming them when in fact you're, and so now the narrative you're hearing from most of the Dreamers is, my parents did nothing wrong, and I don't want them blamed, and there's been a little bit of a twist on that too, and I think this is one of the reasons we sought to, only about a third of the people who were eligible to renew DACA actually renewed, and a lot of the reason was this belief in the community, you're going to come after your parents if you do this, when in fact you put no information down about the parents on the form.
So we're out of time, but I just wanted to ask that you all join me in thanking our panelists for taking Thank you for coming, and I hope that you will continue to come to these type of events starting October 30th.